All persons having business before the Honorable Chief Judge and Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in the session. Please come to order.
Good morning and welcome to the District of Columbia Court of Appeals for our virtual oral arguments. As you know, we've been holding our oral arguments virtually on this platform during the COVID-19 pandemic. Our arguments are being live streamed for public access to the arguments. Today we have two matters set for oral argument. The first matter is Malcolm Cobb v. United States. Counsel, are you ready to proceed?
Yes, Your Honor. Well, good morning. I was expecting that there were other panel judges, but I guess it's just you.
No, there are three of
Okay.
us. I don't know if you can
Okay,
expand the view
I
on your
can see it
screen.
now.
And
Yes.
appellant's counsel is also on the screen. So we're all here with you.
Okay, all right. Well, good morning. My name is Valerie Wortham, and I will be representing the appellant Malcolm Cobb in this matter. And I would request 5 minutes for rebuttal.
All right, thank you. All right, and then just to be clear, these are two cases that we've consolidated.
That's correct.
19 CM 0359 and 0374.
Yes.
Okay.
Okay, so in the first case, the allegation is that the trial court abused its discretion by finding Mr. Cobb guilty of theft in this case. But it was the government's duty to preserve evidence in this matter. It is to preserve any evidence in its possession, custody, or controlled if it is material to the defense's case.
Ms. Wortham, can I jump in just a little bit to clarify your argument on this point? This was a theft at Home Depot involving the store employee, special security officer, and the items that were being stolen by Mr. Cobb were intercepted by the store employee. When he intercepted Mr. Cobb, brought him back into the store and returned the items to the shelf. So I guess, do you have other examples where we've extended Rule 16 in this kind of context? You know, the police were not involved. You know, we're talking about a store employee of a Home Depot who confiscated the items that were being stolen or attempted to be stolen by Mr. Cobb and returned them to the shelf after there was documentation of the incident.
No, I didn't find any case law that was similar, but I'm asking this case to set a new precedent so that it bars this type of justice, this brand of justice in the future. So this would be precedential.
I guess what kind of ill will? Don't we have to show some ill will, not preserving the evidence? And here, I think it were some power tools. They were still in the store packaging. The store employee witnessed Mr. Cobb exiting the store without paying for the items. That was his testimony. So the evidence wasn't destroyed. It was merely put back on the store shelves, and the video essentially captures the items. Correct?
Well, I'm not so sure about that. I mean, the allegation is that he stole power tools, but there has not been any evidence that it was power tools that were taken.
But who cares? Like, what if what he stole were decorative boxes, empty boxes on the shelf? All that second-degree theft requires is stealing something. It has no minimum value requirement. So why do we care what was in the box?
Well, it's not about the value, it's the identification of what was stolen. And here, the allegation by the government is that power tools were stolen, but no evidence was ever presented. There was no photograph of power tools that were taken. There was video that was presented, but in the video, it's unclear, it's very fuzzy. You can't really tell what's in this shopping cart. And, and the final blow was the SBO, Mr. Benton returned the items to the shelf. So, really, we don't know what was taken,
Okay,
or
well, we
if
know
it was
that-
taken at all.
Sorry. Go
I
ahead,
was going to
Judge
say, well, we know something was taken. There's video that shows that it was taken out of the store. He was stopped outside the store, and we know he didn't pay. And we know Mr. Benton testified as to what the items were. You say there was no evidence. I'm trying to understand your testimony as to no evidence, and evaluation, as you acknowledge, wasn't an issue in this case. As my colleague suggested, why does any of that matter?
Well, because Rule 16
What
needs to be.
would your line of cross-examination have been? How would that evidence have helped your client in this case?
Well, under Rule 16, any evidence that's in the possession, custody, or control of a
I
government
understand
agency
that. I'm
has to
assuming
be
for the sake
preserved.
I'm assuming for the sake of argument that you're correct. Now, they should have preserved it. They didn't preserve it, but let's assume they had preserved it in this case, and they shown that it was something other than power tools. Let's
Okay.
assume that they had it. It was the boxes that my colleague has suggested he walked out of the store with, decorative boxes.
Well, the law.
How was your client prejudiced by, how would he have, what would have been his line of defense had he walked out with boxes that were decorative as opposed to power tools?
Well, there's still certain evidence that needs to be presented and honored, and the laws. And here in this case, it was not authenticated. There was no foundation as to what the evidence was, or if there was any evidence. When you looked at the video, there was no personal knowledge by the police officer or the special police officer in this case. He was not able to properly authenticate the videos.
Well, that's a different issue right now. So I just was curious about your Rule 16 issue. And so thank you for your answer.
Now, on the argument of the proper authentication of the video, what's the basis of your argument that it wasn't properly
Well,
authenticated?
the SPO didn't have any personal knowledge of what was on the video. I think in order for him to say that he had personal knowledge, he would have had to be in a position to view what was occurring in the store at the same time it was being recorded. But what appeared to have happened.
Why do you think that? I mean, authentication of a video does not require that the person authenticating it saw everything that's on the video. It requires them saying, yeah, that looks like the video from our store on that day. And I recognize it because that was the day I saw Mr. Cobb walking around as I see him on the video. The finer details of the video I didn't see personally, but I know that's video from that day. I mean, that's what authentication is. But why do you think it requires more than that?
Well, because he was testifying based on personal knowledge. He testified that he actually saw occur what the video showed. And he didn't, when the video was played, or the recording, the surveillance video, it didn't show that he was anywhere in the range of sight to be able to view the things that he asserted had occurred. So it seemed like it was a mischaracterization or misinformation.
He does see pieces of the video. There are is 3 distinct segments of video that were admitted into evidence. And on one in particular, you can clearly see Mr. Benton observing Mr. Cobb go in, and then at a later point in time, he comes out with a cart full of items and does not pay for them. And Mr. Benton is seen chasing him out of the store. So there are key parts of the video, if indeed Mr. Benton was required to have witnessed firsthand everything on the video, which I'm not sure would be required for authentication of the video. He does witness key components of it. some might argue, the most critical point in time, which is when Mr. Cobb exits the store with the items without paying for them. Can I, unless you have any other arguments on the theft charge, Ms. Wortham, could I turn your attention to the BRA?
Okay, I don't have any further argument
On the theft.
on the theft, so
Okay.
I'm
On
prepared for the BRA.
On the BRA, I guess I am concerned about how there's this essentially a presumption that willfulness, at least an initial presumption, can be presumed from a failure to appear, but then there's an opportunity for the defendant appellant to provide evidence showing special circumstances as to why they didn't appear on the date in question. And the trial judge essentially discredited Mr. Cobb's testimony. Mr. Cobb also submitted medical records showing that he had a severe, very severe condition of conjunctivitis, and I forget the medical terminology used in the medical notes. So much more severe than a simple pink eye that we might be familiar with. That was highly contagious and worsening in the period of time leading up to his court date. And Mr. Cobb testifies to that, but the trial judge discredits his testimony. Mr. Cobb's mother also testifies. And I guess my first question is it your understanding that the trial judge made or did not make any credibility findings on the mother's testimony?
He did. The trial court did make a credibility finding on the mother's testimony as well, finding that her testimony was not credible either. But I thought it was very interesting that the court made a statement itself during sentencing that it did not believe that his failure, Mr. Cobb's failure to appear, was intentional. And after saying he didn't believe it was intentional, he said, and that's not a defense. So, saying that it is not intentional is a defense, because it's the very crux of the issue that his failure to appear was willful. So if the judge believed it was not intentional, then it wasn't willful.
Is it right that, so I'm wondering how much import we can attribute to the statement made at sentencing that was made by a judge who wasn't the same judge who found him guilty of the BRA violation, right? I believe the guilt finding was handed down by Judge Motley, and then Judge Cannon was the sentencing judge. At least that's what the transcripts say. And I wanted to know if that was right, or maybe they've just identified the wrong judges on the cover of the transcripts.
Well, I'd have to. Well, I would need to take a look, but that it has to be presumed that the judge who sentenced him, or the judge who made the comment, still had had some say about the credibility of the witnesses and the credibility of the case, and that should have some merit.
So what would you be asking? What relief would you be asking from this court with respect to the BRA?
I think the case should be dismissed. I thought that Mr. Cobb proved or showed a significant amount of significant special circumstances that would show that his failure to appear was not willful.
So you would be asking us to conclude that the trial judge's credibility findings were clearly erroneous?
I would.
Why?
Because his findings were unreasonable, and anytime when credibility findings are unreasonable, they can be disregarded. And I thought it was unreasonable in this case because there was an overwhelming amount of evidence showing that Mr. Cobb was incapacitated, that he was debilitated. And I didn't think that the court gave any of that the proper weight or consideration.
I thought you were making a slightly different argument. So let me just check. I thought part of your argument was not, it was unreasonable to find that he willfully did this. I thought part of your argument was it was legal error to find him guilty when the court in fact did not find that he willfully did this. It found it unintentional. And at another point in its findings, it said, well, maybe he didn't show up because he was told by somebody not to. And that would also seem to obviate willfulness. So I thought you were making a claim of legal error, but now it sounds like you're saying, no, based on this evidence, it must have been, it was clear error as a factual finding to find that this was willful. Are you making both arguments? Just the second?
Well, it was unreasonable and it was erroneous. So yes, to both.
In this case, because I understood your argument in a way similar to as my colleague just described, Judge Deal just described. But with respect to the erroneous findings, how does the presumption fit into your analysis that the findings themselves were erroneous? There's a presumption there that has to be overcome. So you're not saying that it was rebutted and that no reasonable fact finder could find that his failure to appear was intentional, or are you?
I would say that. I would say that, yes.
Okay.
And the reason it was unreasonable is because for some reason, a lot of the focus was on the conjunctivitis. That was an important piece of the evidence, but there was so much going on. Mr. Cobb was juggling a lot at the time, just had a full plate with his mental illness, which was, an existing and continuing mental illness, with bipolar and PTSD. But he, just within days before he was to appear in court, he was attacked on 2 separate occasions, days apart. The first time he was attacked by a group of people, he was kicked in the head. He had, a doctor found, and it was in his report that he had some sort of head injury. And I know there was some discussion about whether it was brain injury or head injury, but he had a head injury from that first attack. And then he was later stabbed in the eye with an ice pick. And that was something else that was discussed. So he was homeless. His mom had kicked him out of the house. He was asked to leave because of the conjunctivitis. But he had a lot going on, and I didn't think that the court gave it the proper consideration that it needed. So, on the day that he was to appear, he was explaining that he was not able to see well, that he didn't have a phone, he couldn't communicate. He had been relying on his mother to remind him of his appointments. And, he was in quarantine pretty much and isolated from other people, and he relied on his phone. But he was saying that during those days, his phone was missing, it fell, it was broken, but he couldn't see, and probably couldn't see not only because of the conjunctivitis, but because he had been stabbed in the eye with an ice pick. I'm sure that affected his vision. And, with the head injury, having been kicked in the head. So those are other things besides the conjunctivitis.
Okay.
And I know that the trial court also made, an argument that it had, he looked at the medical records and his condition hadn't worsened, and assumed that if he was, in really poor condition, he would have continued with his hospital visits. But, we're talking about someone who had no insurance, no money. Even when he was given a prescription, he couldn't fill the prescription. He couldn't afford to, and he couldn't follow up with any home care because he was not in a pristine environment. He was living out of a car or on the streets or, on someone's front porch. So these were all weighty matters for the judge, for the trial court.
All right. Thank you, Ms. Wortham. Unless there are any other questions from my colleagues, we'll hear from Appellee's Counsel. Ms. Wortham, would you mind muting yourself because it's a little bit of feedback and may minimize that. Thank you.
Chief, for the record, I don't know who would control this, but if Mr. Brandon or if it was Ms. Wortham, but for purposes of the purposes of this proceeding and the fact that it's being live streamed. Her title as appellee is incorrect in this in the Zoom. At least it appears to say appellee to me.
I see that. And Ms. Wortham is the appellant's counsel, so. Whoops, I think we just lost Ms. Wortham.
No good deed goes undone.
I'm sorry, she's coming back in, Chief Judge. She's popping right back in. Okay.
Okay.
I was trying to rename her. Oh.
There she goes. All right.
Okay, give me 1 second.
Thank you, Mr. Brandon.
Okay, you're welcome, Your Honor. All right.
Yeah. All right, counsel for appellee, are you ready to proceed with your argument?
Thank you, Your Honor. May it please the court, my name is Ethan Carroll and I represent the United States. I'd like to begin by focusing on the Bail Reform Act, or BRA matter.
Ms. Wortham, I'm sorry, Mr. Carroll. Ms. Wortham, could you mute? Thank you. Okay.
In the BRA matter, the evidence was sufficient to establish willfulness because the government established its prima facie case and the trial court discredited appellant's proffered circumstances. In many ways, this case is indistinguishable from Lanian, a 2020 case from this court, where
I'm sorry. Go ahead. I was, maybe you could address Lanian in the context of my question,
okay,
which is, did the trial court give full consideration to the evidence being presented on behalf of Mr. Cobb to refute the presumption of willfulness?
Absolutely. There were a number of different potential special circumstances that arose from appellant's testimony. They included his eye condition worsening, potential cognitive difficulties, a person telling him not to return to court, that he had lost his papers, that he was unable to come to court because of his eye condition. And the trial court discredited each and every one of them.
Let's talk about that for a second.
Okay.
The trial court says that he didn't show up to court, and this is quoting from page 61, maybe because somebody told him not to come back in the situation. It doesn't sound like it's discrediting him. It sounds like the court is entertaining that possibility and saying, still not good enough. I'm not so sure that's right. So why do you say the court discredited that explanation?
With brief indulgence.
Yeah, it's at page 20, line 21 to 22 at page 61.
I am just pulling that up. So I guess the trial court, this is actually based on a concession that appellant's counsel made below. So I believe it's on page 20. So there are two different points that are relevant here. One is on page 20 of the May 1st trial transcript, where the trial court explicitly asked appellant's counsel whether his defense was that he didn't return to court because a person told him not to return, and appellant's counsel conceded no, that wasn't his defense. And then Judge Motley in his findings, and this is on page 60 of the trial transcript, said that he never testified that that's why he didn't return, and in fact he was around other people in the same time period. So that's a page before where Judge Motley is actually addressing, I guess, the concession, then also the fact, and then also discrediting that testimony because, or I guess the legal import of of the person telling him not to return because of the fact that during the same time period, appellant in fact was around other people. So, even assuming arguendo that there wasn't a concession, the fact that appellant was around other people at the same time period makes clear that that wasn't the reason that he didn't return to court.
So
there
there
was no question.
There's no testimony, Mr. Carroll, by the appellant that he was told that he did not have to come to court or told not to come to court?
There was testimony, but Judge Motley did not credit that was not the reason that he, in fact, didn't come back. And appellant's counsel conceded that was not his argument. So both as a matter of fact and then as a matter of, I guess, a legal bar to making that argument now, it's doubly, I guess, doubly inapplicable.
I don't know that saying that's not my principal defense, Your Honor, is the same as conceding that it's not a basis to acquit. So, for instance, there is testimony from Mr. Cobb that he didn't show up to court because his eye was contagious. He says that quite clearly at page 99 of his testimony. And then when the court makes its findings, and again, maybe you can explain to me why Judge Cannon is on the May 2nd transcript instead of Judge Motley, if that's a mistake or if that's accurate. And then the trial court, when it makes its findings, says, oh, there was no evidence that he didn't show up because he was contagious. That's just wrong. He said exactly that. So, I guess I'm wondering what to do when the trial court makes these findings and says, well, he doesn't say it's because somebody told him. He doesn't say it was because he was contagious. But in fact, he says both those things.
I guess so. Addressing the more particular point, I actually had not focused on why Judge Cannon's name is on the transcript. Okay. Everything about the transcript reads like Judge Motley.
Okay. I wasn't sure if they just put the wrong judge on the. It sure sounded like the judge who sat through the testimony.
And that's how it appeared to me. But I actually don't know. Okay. And there are references to, I guess, by defense counsel to the earlier days proceedings and the fact that the judge had indicated that he would make further findings if requested. It makes it seem like it's the same judge.
That makes sense.
And so I guess the way that I, addressing the other part of Your Honor's question, the way that I read the points that Your Honor is referencing is that there's no evidence that was credited. This is much the same issue that the government takes with appellant's argument, which is that, in looking at whether there are legally justified reasons for not going to court, the findings or the facts that are relevant are those that were credited.
But we can't. I feel like that oversimplifies it a little bit here, because crediting the demeanor of the witness is one thing, but for example, in addition to the two examples that Judge Deal gave, where there seemed to be some inconsistencies or disregarding of what the evidence was showing. The trial court found that the 6 medical records that Mr. Cobb submitted into evidence about the condition, and we're calling it conjunctivitis, but I wish I could find the exact name. It was a much more serious type of eye infection, not the pink eye that we may be familiar with from childhood. And the medical records indicate, the trial judge said that they didn't indicate anything about how long the condition would last. But when I look at the documents, particularly on September 14th, 2018, the doctors report Mr. Cobb's condition worsening, burning sensation, blurred vision in both eyes, and he was informed that his infection would take many weeks to resolve. And that many weeks would take you up to the time that he was supposed to appear in trial. And, a credibility finding that his condition didn't get worse seems to be in tension with what the medical documents say, that in fact it was worsening and was going to get worse. And then when you add to that the medical records explanation of what Mr. Cobb needed to do to address the condition, pristine hygiene, intensive avoidance of other people because it was highly contagious, and Mr. Cobb's own explanation that he wasn't in a situation to manage the condition in accordance with his doctors. It seems like a credibility finding oversimplifies or maybe doesn't fully account for all of this evidence.
So
I guess one final piece, I know this is a long question, is the mother's testimony, Mr. Cobb's mother's testimony. And I had asked appellant's counsel whether the trial court explicitly discredited all of her testimony, because her testimony corroborates in many key ways the medical records about the contagious nature, the worsening nature of the eye condition, and the debilitating nature of it. And it doesn't seem like key parts of her testimony were specifically addressed by the trial judge.
So taking the first part of Your Honor's question first, there
I
are.
don't even remember what the first part of it was.
I got you.
Mr. Carroll, so you're very good.
I've got you. So there are indications in the medical records that the condition may take several weeks to address, but the final medical record in that 10-day period indicated that there weren't worsening conditions. And when asked,
Which record are you referring to?
so that would be, I believe it would probably be Defense Exhibit number 6, which would be, I believe, the September 18th medical record. It indicates that the condition hadn't worsened from I believe it was the prior day. And then, I mean, the legal standard is clear air. It's a permissible view of the evidence that someone who went and sought out medical attention, I believe it was 6 times in 10 days, but then didn't go and seek attention in the following 3 weeks, didn't face worsening circumstances. I mean, that's a permissible view of the evidence. And under the prevailing standard of review, it's not clearly erroneous.
And remind me what your response to Ms. Wortham is, that at sentencing, the trial court explicitly says, I don't think this was intentional.
I do want to make sure I will flag just that
there
I want
are other parts to her question. Sure.
Do you mind if I address the Chief Judge's second question first, and then I'll come to Your Honors? Okay. And then on the now I'm going to have trouble remembering it. So I believe the second part of Your Honor, Judge Bachman-Redke, your question. Oh, now I've forgotten it. I'm sorry.
I think it had to do with the mother's testimony
okay.
and
Yes,
discrediting of the mother's testimony.
So I actually don't read Judge Motley's findings as broadly as I believe that appellant does. In relevant part, this is on page 62 of the trial court's findings. Judge Motley discredits the circumstances that appellant offers, but there isn't specific mention of appellant's mother's testimony, except to the extent that it differed from appellant's. And Judge Motley did make findings about the inconsistencies in the 2 witnesses' testimony, and found, for instance, that unlike appellant's mother didn't testify about appellant, in effect, being blinded, and that they testified differently about appellant's ability to communicate with appellant's mother, and also to get around. So I didn't read Judge Motley's findings as a across the board discrediting, but on what matters, on whether Judge Motley credited the proffered special circumstances, which is the legally relevant test under Lanyon, under Evans, under Foster and Raymond. Judge Motley did discredit the proffered special circumstances.
Well, if I could ask just one more follow-up question, and I know that Judge Deal had a question for you.
Got Judge Deal's question pending.
in Lanyon, we remanded where we found that certain testimony that might be potentially exculpatory hadn't been fully explored or reviewed or considered. If we thought that the mother's testimony, and she testifies to some key things about his mental state, his forgetfulness, the worsening condition of his eyes, the fact that he literally couldn't get around without somebody helping him. Those are key potential pieces of testimony that seem to corroborate the medical documentation at some point. Why wouldn't a remand, similar to what we did in Lanyon, be appropriate in this instance?
In large part, it's about the role of the two different courts. Appellant made an argument below and asked for specific findings, and Judge Motley rendered specific findings on each of the points that he urged during his argument. And for him to not even in his brief or in his reply brief, but instead, based on this court's sua sponte questions about the import of his mother's testimony and whether a remand is appropriate, just wouldn't be consonant with the role of this court versus the trial court. Judge Motley, made clear that he was willing to render further findings as requested, and answered appellant's questions during the May 2nd sentencing hearing. And then, if I could, pivot a bit to Judge Deal's question, when it came to this matter of intentionality and willfulness, appellant stood silent. At the end of a transcript where Judge Motley repeatedly stated the correct legal test and circumstances, and then at the very end of the hearing made a comment about intentionality. For appellant to stand silent is evidence of the lack of prejudice that he perceived from that comment, and the extent to which he understood Judge Motley to be addressing what Judge Motley said he was addressing, which was mitigating the sentence, not making a separate finding about intentionality or in any way overruling his finding from the previous day, but instead doing what he said on page 22, which was that he mitigated the sentence because of the eye condition. Later, immediately after the comment about intentionality, Judge Motley indicated that the reason that his issue was that appellant's explanation, but it was, I'm not going to go to court, I'll let them come find me. And that is something that, you simply can't do, and then urge the court to find that your appearance wasn't willful. I would emphasize in Lanyon that, which was and I guess actually, sorry, let me address the rest of Judge Deal's question. I guess at most, appellant would be entitled to a remand. I think both Chief Judge and Judge Deal, probably that your questions implicitly recognize that. To the extent that there's any ambiguity, the recourse wouldn't be reversal, as appellant is urging, but would just be a remand for clarification on any ambiguity in Judge Motley's question. But as I stated a moment ago, that just isn't necessary or appropriate here, given that appellant's counsel stood silent and given the context for Judge Motley's findings. So on page 20 through 21 of the sentencing transcript on May 2nd, Judge Motley reiterated that although appellant was going through a lot of hard times, I did not think that affected his knowledge of the trial date or whether he should come to trial or whether he forgot. I don't think that his testimony was truthful. That's the correct legal standard. And there isn't any reason to believe that Judge Motley was in some way undermining his findings from the day before, when in the same sentencing transcript he stated the correct standard, when in response to appellant's specific request for factual findings, Judge Motley indicated that he did find that the failure to appear was willful and discredited appellant's proffered special circumstances. And frankly, it's consistent with this court's standard for willfulness in both Evans and Lanyon, which is that willfulness includes plain indifference to a legal duty.
Can I just ask, and I know your time is out, so this will be my last question.
Okay.
I went back to look at page 60 of the trial court's findings. I think this is April 30th, because you pointed me to that when I mentioned that the trial court said maybe he didn't show up because somebody told him not to. What the trial court seems to say to me is, he says, well, what if the person said that? What if the person told him not to come to court? Now, he didn't say he didn't come to court because of his eye condition. A, that's false. He did say that. And then he says, but that would have been insufficient. Insufficient, which I take it what he means is that's an insufficient defense, even if it were true that he didn't show up because of his eye condition and because somebody told him not to show up to court, which the trial court seems to be entertaining as one possible view. Do you think that's right? If somebody says someday the court told me I couldn't come back because I had conjunctivitis. Do you think that's not a defense to a BRA violation, that it was willful when you didn't show up?
I guess 2 points. One is not if you don't say that that's the reason that you didn't show up.
He said it. I mean, I'll point you to it again. It's on page 99 of his testimony. He says, "Why didn't you come back to court in October? I had the eye disease and it was bad. It was hurting. I couldn't see. It was hurting. It was contagious." Seems pretty good to me.
No, sorry, I guess I misunderstood your Honor's question. I thought that you were referring to the testimony about not returning to court because someone told him not to.
Oh, I think both.
Okay.
I think having testified that somebody told him not to come back to court, and then when he's asked why he didn't come, he said, "Well, my eye was still contagious." I think that fairly incorporates and I was told not to come back with contagious eye. I mean, I don't think you need to say specifically. I don't think you need to tie all the threads in your testimony together. I think it's a fair reading of it to say he didn't show up because his eye was contagious and someone told him not to show up.
I guess that's one permissible view of the evidence. There's an equally permissible view of the evidence, which is that he was reiterating the thing that he'd been saying during his entire testimony, which was that the eye illness contributed to a general confusion and forgetfulness about the fact of his legal obligation. Given that there are two permissible views of the evidence, the standard of review requires that this court take the evidence in the light most favorable to the government and review the evidence for clear error. So just because it's a possible reading of the evidence doesn't mean that it's the one that this court's obligated to follow under the applicable standard of review. And then I guess I would just emphasize that was never, at least appellant never made clear, and his attorney never made clear, and in fact said that he wasn't relying on this statement by a person, an unidentified person, not to come back to court, that was the reason that he didn't come back. So in light of that lack of testimony, in light of appellant's counsel's concession, that wasn't his defense, not that it wasn't his primary defense, but that wasn't his defense, and that we would submit that the evidence was sufficient to establish willfulness. If there are no further questions, I'd ask that this court affirm the judgment in each case.
All right, thank you, Mr. Carroll. Ms. Wortham, you reserved a few minutes for rebuttal, I believe.
Okay, so the one thing I want to address is the question of why he didn't return to court. And I know there was a statement made by him that there was someone at the courthouse who made a comment to him about his conjunctivitis and, not to come back here because it's highly contagious. But I think on the date that he was to appear on October 10th, I don't think that was one of his main considerations, even though it is a consideration. I think at that point in time, it was his state of mind. It was, him saying on that day, I didn't realize I had to go to court. I didn't even know that I had missed court. I didn't know the date. I didn't know what day of the week it was. I didn't know what time it was. And, and add to that, I didn't have my cell phone, and, I relied on my cell phone, but then I wouldn't have been able to see it. I couldn't even see what, the date or anything on my cell phone. So even though, the person who made that comment affected his judgment or his decision to go to court, I don't think that he was it was the main reason he didn't go on that day. I don't think he was thinking about it at that moment. It was his condition. So if there's no further questions, I would ask for a reversal in this case.
All right. Thank you, Ms. Wortham. I'd like to thank both parties and counsel for your briefs and arguments today, and the case is submitted. Thank you. And you can feel free to exit our virtual courtroom as we have one remaining matter after this one.
Thank you, Your Honors.
All right. Good morning, counsel. I see 3 attorneys in this matter on the screen. I just wanted to confirm who's participating in the oral argument. This is the case of Atkins LP versus O Street Management LLC. And our court records show Mr. Jessamy as counsel for Atkins LP, the appellant, and arguing for the appellant, and Mr. Kernan as counsel for appellee O Street Management. I'm also showing Mr. Bell on the screen. And if you could just, for clarification, let us know your role in this matter, Mr. Bell.
Yes, I'm co-counsel with Mr. Jessamy, but he is doing the argument.
Okay, thank you. All right, are counsel ready to proceed?
Appellant is ready, Your Honor.
Okay. You can proceed, Mr. Jessamy.
Good morning. My name is Ronald Jessamy. I represent the appellant in this matter, and I will be arguing the case. I'm joined by my co-counsel, Mr. Robert Bell, who's on the brief.
All right, did you wish to reserve any time for rebuttal, Mr. Jessamy?
Yes, Your Honor. We would like to reserve 3 minutes for rebuttal.
Okay, thank you. All right, you can proceed.
Okay, now, for point of clarification, do I understand this argument is for 15 minutes?
Yes, it is. You don't have to use all 15 minutes if you don't need it.
Well, I hope I won't need it.
Certainly, if you do, you have 15 minutes.
Well, this matter is on appeal from an order from the trial court that was entered on a motion to dismiss the Atkins complaint, who filed for a enforcement of a judgment. Now, I will point out to the court that the trial court made at least 2 errors in its order. First of all, let's take the easiest one probably to dispose of, is that the court treated the motion filed by Atkins to be a complaint to enforce to be a complaint to for a breach of contract. Well, if the court would look at the appendix where a copy of the complaint is filed, there is not one word, not one sentence, not one paragraph that suggests that the relief sought by the plaintiff in the case below was for breach of contract.
Mr. Jessamy, I'm sorry.
Yes, Your Honor.
In your complaint, did you list the judgment that you were asking the court to enforce? Was a reference made to the judgment, or how was that characterized in the complaint?
Well, Your Honor, the complaint appears at page 40, beginning at page 40 of the appendix. And there is a reference, paragraph 11, where it says that the court concluded that the value of Atkins' interest in O Street Management was $721,000. In paragraph 14, there's another reference to $721,000. And that all goes back to the order of the court below that was entered on January 24th, 2012.
It's referenced in paragraph 16 as well.
Okay, I'm sorry. Thank you, Your Honor. Now, what appears to be the more problematic issue is that the judge below indicated that there was a there was no judgment entered in this case. Well, the judge is wrong. I say that he is wrong simply for the fact that if the court would look at the order of 2012, where the court had, and that can be found at pages 148 to 158 of the appendix, where it says ordered that the plaintiff's motion to confirm valuation and order settlement is granted.
I think what the trial court was trying to say is that there was no money judgment issued in the case. And really, that's what we're here to talk about, because whether or not there is a money judgment, it doesn't matter if you say that you filed a motion to enforce a judgment. If you don't have a money judgment, you're out of luck. So I think what the trial court was saying was there is no money judgment. This is really a contract dispute, and the statute of limitations has run for that. So what's your argument that that January 2012 order is a money judgment?
Well, as an opinion that was penned by Judge Washington in the earlier case of Hogue versus Poham, there is a recognition of the fact that there is no requirement that there be a money judgment set forth on a separate piece of paper. And below, what happened earlier when O Street filed to have the order of December of 2012 confirmed, my clients had filed a motion to set that order aside. And
there's no doubt that there is confirmation of an appraisal value. But let me just ask you a hypothetical, which is different from this case. Let's say no buyout had been ordered by the court prior to or after an appraisal took place. But there was simply a dispute about what that buyout price would be if O Street wanted to exercise the option to buy out. If the court said, well, that number is $720,000 if you feel like exercising that option, end of story. I take it you'd agree that's not a money judgment, right?
well, that may not be a money judgment, but there are other places in the record that show that the court had ordered that that amount of money be paid. I will point directly to the order of December 25th of 2015, which appears at 178 of the appendix. And in that, the court has, excuse me while I mess around with these things. The judge said, the matter concluded on October 25th, 2012, with the issuance of an opinion from the District of Columbia Court of Appeals affirming the trial court's order of O Street must pay ALP Atkins Limited Partnership $721,000 for the buyout of Atkins Limited Partnership interest. So, and the operative words here is that O Street must pay.
And we don't even need to get to 2015 because the same thing is in the January 2012 order. It says the remaining issue is what price the plaintiff was to pay defendants in the buyout, right?
Right.
And in the September 2011 order, it also says the only remaining issue is how much the plaintiff must pay the defendant in the buyout. The language appears over and over again, both in our decision in 2012 and in the trial court's orders, both leading up to and after its January 2012 order.
And in now that you mentioned your opinion of 2012, at the end of the opinion, it says, for the foregoing reason, the judgment of the trial court is affirmed. That's on page 169 of the appendix.
Well, like I said, I don't think that matters. I mean, there's certainly a judgment. It's just a question of whether or not it's a money judgment. And so pointing out that there is a judgment, I don't think gets you anywhere.
Well,
So it's a judgment of some variety. There's no question about that.
but and the other language that I had pointed out was said must pay $721,000. So I think that does not leave any room for doubt that the $721,000 is a collectible amount of money from O Street.
So one thing that O Street says is that was $721,000 that required you to come to the table and settle. The trial court's order was O Street pay him $721,000. Adkins come to the table and settle within 90 days. You didn't seek a stay of that order or anything like that. And you didn't do your end of that bargain. So why doesn't that make this not a money judgment, but two directives and you violated yours, so they're free to ignore theirs?
Well, first of all, I don't believe that the Atkins Limited Partnership failed to do anything to make the prior orders unenforceable. And I would also point out that even in the appellee's reply brief in this case, on page 15, there is an acknowledgement by it that while a judicially confirmed arbitration award is enforceable as a judgment, and then they go on, they acknowledge it is enforceable as a judgment, but then they go on and try to distinguish without really making a difference that that's not what they have here. And I don't know why, with their filing a motion to confirm the judgment, they are not stopped at this point from now arguing, look, confirm the order, while they're not stopped from now saying, look, we don't have anything.
Mr. Jessamy, can I ask just a couple of hypothetical questions? If hypothetically we were to agree with O Street that this was a breach of contract and not a money judgment type of case, would there be any remedy available for Adkins?
At this late stage? No.
Yes.
And we don't think that when they filed when Atkins filed its motion to enforce a judgment, that a breach of contract action was even viable at that point. Of course, more than 3 years had passed.
Okay.
I wonder why you concede that point, though, because the payments were supposed to be made over a course of 5 years. It would have taken you into 2017. And there's also a contract provision that says at the end of those 5 years, any amount due comes due, and any amount that hasn't been paid comes due. So I'm not so sure you didn't have a viable contract claim, but I think you've abandoned that at this point, right?
Well, yes.
You don't take issue with the court's statute of limitations finding if it correctly interpreted your claim as a breach of contract claim, correct?
I would not.
All right. Anything further at this time, Mr. Jessamy? I know you've reserved rebuttal time.
Well,
Okay.
We'll submit
I
on
have
open.
one. I'm sorry.
Judge Washington?
Yeah, I had really one question. The declaratory judgment motion, the judgment is granted is language coming out of the declaratory judgment motion that I believe your client filed, Mr. Jessamy. What did you understand that to encompass?
I understood that to encompass what my clients were seeking, payment of this $721,000, pure and simple.
Okay. All right. I'm sorry. Thank you.
All right, at this time, are you ready to proceed, Mr. Kiernan, on behalf of the appellee?
Yes, Your Honor. Thank you. May it please the court. This appeal, as your questions have elucidated, is really about the single issue of, did Judge Mott actually enter a monetary judgment? And until this case was filed in November of 2018, no one in this process had ever asserted that a monetary judgment had been entered. And I'm talking about Judge Mott's original order, when this court affirmed the appraisement decision.
How do you then interpret the orders from, I think, 2009 and 2012 that we've been referencing that say O Street must pay Atkins?
The reference I think maybe Your Honor is referring to is the 2015 order that the Atkins interest spent a lot of time in the reply brief on, where Judge Mott makes a comment about an order to pay or a judgment to pay the 721.
I just want to add, I don't want to interrupt your answer to your question, but it also appears in the September 2011 order where the court says the only issue remaining is how much O Street must pay.
Right.
And in the January 2012 order, that's at issue here, what price the plaintiff was to pay defendants. And then our 2012 affirmation of that, which said the only issue is how much money they must pay. So it appears a lot.
Understood, but all of those references are in the context of the contractual relationship between these two parties. And I'll remind the court that at the time of the 2011 order, the 2011 order and 2012 decision by Judge Mott, we were in the process of trying to implement a contract provision in which we pay 25% down and there's a note that's payable over 5 years. We tendered that performance to the Atkins side. They said, we won't participate. And so we tendered it to Judge Mott. And so it is clear that when Judge Mott's talking about that, it's in the context of a contract that has these provisions. And that's why the suggestion that in January of 2012, that even though there was no pending request anywhere for an order to, or for, excuse me, for a monetary judgment for us to pay them a certain amount of money, they had no claims pending at that point.
You actually made that request. You say you requested an order that you are required to pay $721,000.
We requested entry of an order affirming the price to plug into the contract.
Let me
I'm
going to quote from your reply in the motion to affirm the appraisal. You asked for an order, and this is quoting, directing the execution of appropriate documents and payment of required amounts so that the buyout is completed no later than August 2nd. You're saying, you're asking for an order saying pay the required amounts, and that's an order that the court granted.
The order that, more precisely, Your Honor, the order we requested is that they show up by the August date that was the contractual date. Okay, and by the time the judge ruled on it, that date had passed. We had started tendering our performance. They had rejected participating in that performance. So I think you have to read the judge's order on that in that context. Regardless, I don't think it's a monetary judgment that was entered. It was part of the contractual process. And
so let me just, I want you to spell that out for me a little bit. Because when I look at the contract, it says, there's this first question of whether or not you want to exercise your option to buy out. You've done that. The court in 2009 said this buyout is going through. What's left other than giving them the money that needs to be handed over in the buyout? You say, you make references in your brief and here today about, they have some papers to sign. I don't see what is material about that. I mean, in your view, has a buyout occurred? They've been divested of their interest in the O Street property by virtue of what?
By the exercise of our buyout that was confirmed by the trial court and confirmed by this court.
And it was confirmed. It was confirmed before the January 2012 order, correct?
Correct.
So a buyout's happening. The only question is how much, which is what the court and our court has said. That's the only question that's pending. So there are no other contractual issues. Contractual hoops to jump through. It's just a question of how much, and that's what the January 2012 order said.
Respectfully, I disagree with that analysis, Your Honor, and here's why. The the contract, the operating agreement says there's supposed to be a settlement, a closing at which this happens. We were in real time, we were in the middle of trying to put this real estate development together. It's there now, you can see it now. At the time, we were trying to close on financing, we were dealing with tenants, we were trying to make sure that we could represent to the lenders, to the city, to everybody else, that we had control over this partnership. We had asked them to sign the documents like much as you would a bill of sale. I agree with you, Your Honor, the buyout was completed. And that's why in real time, we tendered the money, which they then rejected. And that's why it defies logic that in January, when Judge Mott entered his order, he intended to abrogate the contract, abrogate the note and the payments that had been made, and turn this into a monetary judgment that we must pay Atkins Limited Partnership. That's not what we requested, their participation in a timely manner. We never got that because they never.
Mr. Kiernan, help me with some of the sequencing here. You know, the contract had a provision that required the parties to work with a third party neutral to value the amount of the buyout if they couldn't agree on an amount. And you first got together and you proffered on behalf of O Street the 721,000 number, and it was rejected at that point. And that's why you all had to employ the services of a third party neutral, who then came back with a lower amount, 600,000. And because of the contract provision that says if the third party valuation is lower than the amounts that the two parties negotiated, then the second lowest amount would be accepted. And am I correct that when you were saying you proffered to pay or offered to pay the 721,000, that it was before the process with neutral, and then it was only after the neutral's valuation was lower that the trial judge essentially accepted the 721,000. So it seems like, in other words, correct me if I'm misunderstanding, but it seems like you're saying, well, we first offered the 721,000 to resolve this and they rejected it. But they didn't actually, they were exercising a right within the contract to have a neutral evaluate and then see where that left the parties.
No, Your Honor, just to clarify. So we had an appraiser, they had an appraiser. They were more than 50,000 apart. A neutral is appointed. Once that neutral came back with a number of 680 or whatever the number was, we knew that the 721 was going to be the number. We then tendered the performance based on that number and filed our motion that they close within the 90 days, which was the time limit set in the operating agreement to close. So we didn't want to be in default of starting to pay on that. This was before Judge Mott entered his order. So we were complying with the contract terms. And so it was 25% down and a note for 5 years, et cetera, payable monthly and so forth. And we tendered it, and Mr. Bell said, we reject it. So we
did the contract term require the trial court to approve or accept or reject a number? Because isn't there language in one of the orders where the trial judge says he confirms the $721 amount, which is at a point in time after you make this proffer, go ahead and pay the 721.
Correct. We filed a timely motion saying we need to close within 90 days, which is what the contract requires. Which
right, but I guess my point is, they were within their rights not to proceed until the trial judge actually says that this $721,000 figure is going to be the valuation after the parties follow the other steps in the contract. What's the effect of the trial judge accepting the 721 after you make an effort to offer it, if it's not to actually make it official? And at that point in time, Atkins then accepts the 721 once the trial judge says that's going to be the number.
What was before Judge Mott was to our motion to confirm the results of the process, which would have been the 721 paid over the terms of the contract, not a lump sum 721, and that they appear at settlement and closing to resolve this. We started tendering that performance before Judge Mott ruled. They didn't have the, respectfully, I don't think they had a good faith basis to reject the results of this. But
Well, but I guess maybe this is semantics, but I think it's an important point. The results of this were official when Judge Mott ruled, right? Not when you got ready to start the process.
Well, the results in that sense, Your Honor, the results were what the contract did. We were trying to perform under the contract, right? And the contract required us to start performing.
Well, then why did you need a ruling from Judge Mott if you could just go ahead and self-execute this?
Because, Your Honor, we have been involved in years of litigation brought by this other side, challenging everything under the sun. This is our, I think, fourth trip to this court on this case. And, you know, we wanted, and as I said earlier, we were in the middle of trying to develop this property. We wanted to get this resolved. Frankly, we wanted to get it paid and done. And it was the other side that said, we reject your tender of performance, right? And that's where things stood. And so it was good that we asked the judge to confirm that. And in the earlier appeal in this case, the court specifically drew the distinction between affirming an appraisement and affirming an arbitration. The appraisers in this case did not enter an order that O Street Management pay Atkins anything. They were just doing a valuation number. What got confirmed was the number to then plug into the contract. And that's why we think this is a breach of contract case. We got something, we didn't pay for it under the contract, not because there was a monetary judgment from a court ordering us to pay. And I'll make one other point, Your Honor. We raised below, we raised here. Mechanically, this doesn't look like a monetary judgment, right? There's no separate entry, there's no docket entry. And while that's not, there are cases where that doesn't have to apply, we see the mischief that's caused if somebody then says 10 years after the fact that was really a monetary judgment. You know, there is nothing that looks like a judgment. And even when they filed the case that's before you today, their requested relief was an order that we pay the 72021, basically an order to pay this amount. If they had a real judgment and they were a true judgment creditor, they have remedies. They file a garnishment, they can file whatever, attachment, they can do whatever they want. I suspect that what happened here is they looked at that and decided they weren't going to get anywhere with that. And if they walked into the bank and said, we've got this judgment, they're going to look at it and say, it doesn't say anything about judgment on here. It doesn't look like a certified judgment. And so they're sort of a Hail Mary 10 years after the fact to see if they can reopen this and have judgment at their monetary judgment.
But why isn't it fair, Mr. Kiernan, to view all of the statements, as my colleague has pointed out already, where the court, including this court, has said, and in fact, in your pleadings, you acknowledge that O Street must pay ALP $721,000 for the buyout of ALP's interest in O Street Roadside. I mean, we would have to ignore the court affirming the trial court decision that, in fact, ALP is entitled to $721,000. I mean, I understand your technical argument about they could not walk in and get a judgment enforced on a document that clearly indicates that it's a judgment, and probably could not get loans or other monetary value for what they have here. But we would have to ignore what has been a very consistent mantra from both the trial court and this court that, in fact, they are entitled to $721,000. And I don't understand how you would ask us to ignore what is clearly, if not a sort of technically separate judgment, which we of course prefer, to what is in fact a clear order that says they're entitled, and at most going back to Judge Mott and saying, put this in a order that we can execute upon would be a fair and equitable solution. I mean, it clearly isn't a fair solution for O Street to walk out having a 25% share of this project with all of the money that's been generated. We won't get into the issue, which has already been litigated and resolved, as to whether the valuation process was fair. But I don't understand, frankly, how we can ignore significant, consistent statements from this court and the trial court that ALP is entitled to $721,000, regardless of whether it's in a separate judgment or just in orders that address other things. And frankly, the court, in our prior decision, in which we looked at this as an appraisal only and made it clear this was sort of not an arbitration because those issues had already been decided and were not properly before us. That, again, consistent with this argument being made by Mr. Jessamay here, argues loudly for us to interpret all of this as a judgment, though not in a separate form.
Your Honor, if I may, there's 2 points in your question I'd like to respond to. Number one, I do need to respond to the suggestion that somehow the Adkins interest didn't get what it bargained for. When Roadside first became involved in this property, the Adkins interest, Mr. and Mrs. Adkins at the time, were about to lose this property to foreclosure because it was so underwater. When Roadside got involved in this, the Adkins side walked away with approximately $13 million in consideration, tax benefits, loan forgiveness, etc. Part of what we also came out of that arrangement with was a contractual process to buy them out that was supposed to be short, fast, market-based, and done in 90 days after the numbers. We didn't get that. And I think that, respectfully, Your Honor, the suggestion that we got something for nothing is just not accurate. We did what we were supposed to under the contract. And when Your Honor suggests that the parties either should or the court should ignore the terms of the contract, just abrogate the contract and say it doesn't matter that the contract had certain payment terms, that we tendered performance and so forth, and we should just treat it as if they got a monetary judgment. Because I assure you, if in 2012 Judge Mott had entered an order saying there's a monetary judgment entered, no note, no payment over time, no nothing, we're forgetting the contract. We're entering an order that you must pay them $721, they can enforce it directly. I certainly would have objected to it because that's
Mr. Kiernan, I think you misunderstood my question to some degree. What I was pointing out was, and I said I wasn't getting into the valuation, nor has there been any argument here made that in fact the payment methodology that's in the contract with the percent down and payment over time was improper or illegal, and a judgment to that effect is exactly what I would have expected with the court to enter in an amount of $721 and paid as you have into the court registry that exact amount. Nobody's arguing with that or taking exception to it. What I am suggesting is if I am a litigant who has received several orders indicating that I am entitled to and that O Street must pay me, a reasonable interpretation of that is that I have a judgment for that amount of money, and I don't need a separate judgment. And again, the rest of the contract terms aren't in dispute here. Nobody's arguing that they don't have to pay, that you have to pay them all of the money up front. And the question is, why would we not, or why shouldn't we, given that the contract is viable and enforceable as to terms and conditions, nobody's suggesting it's not, just find that the $721,000 judgment in these orders and in these opinions is valid.
And I think, Your Honor, respectfully, it's because throughout this process, and you've got in front of you communications I've had with counsel, the things that have been filed, no one treated this as a monetary judgment. And what the Adkins people did in October of 2018 was go down to the Recorder of Deeds office and try to file, indicating to me as strongly as possible that they
Can I
didn't
interrupt
pay
you?
the judgment either.
Because they say in 2013, they came to you to collect. You wouldn't pay up. Is that false?
I'm sorry, Your Honor, I didn't hear the beginning of your question.
They say they did treat it as a monetary judgment in 2013, and they got, strung along for a handful of years by excuses. So you might not have thought it was a monetary judgment, but they say we tried to collect on that the second our appeal had ended.
Respectfully, Your Honor, what we were presented with in 2013 and for some time after that was a changing parade of people who had said, it's our money, it's our money. And we said, and I think appropriately, we want confirmation of repayment. During this process, we had relatives show up saying it was theirs. They've had 5 or 6 lawyers over time. We said, we want proof that if we're going to pay somebody, it's the right person. They strung us along.
Did you ever say, but we don't owe that $721,000 to anybody because you didn't settle in 90 days?
No, Your Honor, we were trying to pay them in real time. We tried to pay them.
Well, remember, and you say that they rejected the payment, but the only thing that you point to for that is a May 2011 statement that they rejected $721,000 as the purchase price, which is different than rejecting a payment that they could find. So tell me if I'm wrong.
I think you're wrong, Your Honor, because we once the 721 was locked in as the number, we had obligations to start 25% down and the note. I sent.
But see, when was the 721 locked in? That goes to my question. I thought it wasn't locked in until Judge Mott ordered that was the amount.
The third appraiser, Mr. Master, came back. I'm just double checking the record here. Third appraiser came back on June 3rd of 2011. Oh, I'm sorry. Well, it was around the June 2011 time period.
Actually, your motion to confirm the arbitral award said, we're asking the court, this is at Appendix 144, we're asking the court to confirm this award, which will have the effect of locking in the purchase price at $721,000, suggesting to me that you understood it was the January 2012 order that locked in that price. And at no point after that did you tender the money, right?
I think we tendered another month's payment, and Judge Mott contacted us and said, the case is over. What am I supposed to do with it? Because
but you didn't tender it to them. You didn't say we're willing to pay up now.
We already had tried to. Mr. Bell said we're not taking it. Okay.
Prior to it being confirmed, I understand.
Well, under the terms of, we were complying with the terms of the contract, and we tendered it. Mr. Bell didn't call me and say, can we have the money out of the registry? And which they could have had. I would have been happy to. I mean, again, the issue is not that we were trying to avoid paying, because we were trying to pay. We were trying to pay in real time, consistent with the contract that we had with them. And they kept raising challenge after challenge and wouldn't comply with the contract. So it is not a question of us lulling them into anything. I mean, I couldn't be clearer with my communications with counsel that in our view, the statute had run. We even made them a settlement offer, even though the statute had run, and got nothing except pay us the full amount plus interest. And that's one other thing I just want to say. The suggestion now that somehow they would be paid not only the principal amount, but interest on this, when they did not have and don't have an actual monetary judgment against us for this amount is really not appropriate. There's no further questions. Thank you for your time and your attention.
All right, thank you, Mr. Kiernan. Mr. Jessamy, you reserved a couple minutes for rebuttal, I believe.
I did, Your Honor. I'd like to address several points. One, there was a reference to, quote, payment into the registry of the court. There was never a pen, Judge Mott's chambers and in his hands. And after he decided that there wasn't anything more that he could do, he turned the money back over to O Street. And so my client couldn't even have accessed it if it wanted to. Then you understand that this was a hotly contested matter. This was a highly valued piece of property. And what my clients were seeking was a better deal than the $721,000 out a property that was $54 million.
We understand that, Mr. Jessamay, but the problem is there was a contract. The contract had a very specific provision. The very specific provision was how the buyout takes place. There's really been no controversy about how the buyout takes place. There was a decision by the court years ago now that, in fact, the evaluation methodology that the trial court ordered the appraiser to use was improper. That issue was decided, and it went right back down. So at that point, at a minimum or at the latest, why, at that point it was over. The contract itself was self-executing, correct?
Correct, Your Honor. But if it was, and if it was over, my client had tried to collect on that money after the judicial decisions affirming what appeared to be the judgment.
Mr. Kiernan seems to be taking exception to that, saying that there was no, that they kept asking for some documentation, something that indicated who the appropriate parties were to receive the money, because he said there were several people coming in. What's your response to that?
Well, and that was resolved by the court, the probate court in Virginia, and told him who the actual parties were.
And when was that? Remember?
Excuse me, y'all. I'm gonna look it up. It's June 24th, 2016.
Okay, so in 2016, the parties who entitled to the money were identified. And did you make a request after 2016 for the monies? Those clients, those individuals, and for that payment?
A request has been made repeatedly up to the time that we're up here in the Court of Appeals again. I'd rather for my clients to have had that money in their possession so we wouldn't have to be up here. But there have been repeated attempts by counsel below to try to collect that money.
Okay, so 2016, there was an attempt, because the way I'm looking, the record suggests the last time you were here in the Court of Appeals was 2015. Is that not correct?
No, that is correct.
Okay, so you said they were identified in 2016. And I was asking, was there a request for the money to be paid in 2016 to the individuals that were identified by the probate court in Virginia as being entitled to this money?
Well, two things on that. One, I think that as in most litigation, when payments are to be made, they are to be tendered to counsel of record. And then counsel of record would be the one responsible for distributing it appropriately.
Okay.
But again, there is no sense that my clients had not sought to obtain this $721,000 after the courts had determined that the judgment below was affirmed.
Thank you.
All right, thank you. There are no further questions from my colleagues, and I'd like to thank both counsel for your briefs and arguments today, and the matter is submitted, and you're free to, at this time, to exit the virtual courtroom. Thank you.
Thank you, Your Honor.
This honorable court is now adjourned.